Welcome to the virtual courtroom. Ms. Mogensen, we're ready when you are.
Thank you. Andrea Mogensen for appellant Jason DEMARE. I would like to reserve 5 minutes for rebuttal, please.
Very good.
Good morning. This case is about one count also of traveling to solicit and seduce, commit a sexual act with a minor. The conviction is challenged on the basis that the essential elements were not present. Alternatively, if the court finds that they were, that conviction is barred due to entrapment. The statute under which Mr. DEMARE was convicted, 847.0135, requires 4 elements, 2 of which were not present in the undisputed facts presented in the motion to dismiss. The first and probably the most critical in my view is that subsection D, the 4th requirement, that the defendant solicited, lured, enticed, seduced a child to engage in an unlawful act, was not present. In this case, Mr. DEMARE was seeking adults in the adult side of meetme.com. He discussed with the fictitious Amber for 5 days a relationship that was not premised on sexuality. When he was speaking to what he believed to be an 18-year-old adult, he talked about eating pizza and watching video games and promised not to touch her and promised he wasn't a creep. He was looking to make connections with appropriately aged persons. Law enforcement officers did not suggest that they were, of course, this was a sting and the Amber was fictitious, and it was not suggested until after at least 5 days. The beginning of these conversations was, again, not preserved by law enforcement, the agency, but it's clear when the conversations start that they've been talking for some time because they're on a very extended discourse about the time when he lived in South Dakota and are fairly advanced, obviously, along the way in getting to know one another. But law enforcement officers waited until he was very invested in this relationship with what he believed to be an adult for a minimum of 5 days, but certainly more, before suggesting that this person was actually aged 14. As outlined in our brief, there is no evidence that Mr. DEMARE seduced or enticed any sexual activity. Indeed, the definition of seduce and entice involves commanding, hiring, procuring, requesting, and encouraging. The plain language of the statute requires that Mr. DEMARE have engaged in that type of conduct in order to be guilty of the offense.
Ms. Mogensen, is it fair to say that he may have been inducing, but was it in response to police encouragement or was it on his own? Because that seems to me to be a jury question in many cases. What was the intent of the defendant? What was the purpose of his comments to the purported victim? And so you do have some statements by him which certainly suggest he is thinking about sex, thinking about engaging in sex. But it also seems that much of that is in response to police encouragement to continue that talk or to elicit that kind of statement from him. So how does that weigh into this?
Well, I think that the purpose and the intent is limited in consideration to the second element. The second element of the offense is that the traveling is for the purpose to engage in sexual activity. Importantly, subsection D, the 4th element, which is an independent element that is required to be present or the conviction fails, is that defendant solicited, lured, enticed, or seduced a child to engage in the unlawful act. If there is no inclusion in that 4th element of or intended to do so, or attempted to do so, or meant to do so, the 4th element requires an activity. It requires words. It requires solicitation and luring. And as I pointed out in the briefing, Florida Statute 775-021 sub 1 codifies the rule of lenity, and that statute must be strictly construed. So we can't read into it, well, he didn't say, he didn't do anything to solicit or lure, but he was thinking about sex. That's not the offense. And we are duty bound to follow what the legislature defined as a crime.
Ms. Mogensen, if we look at the totality and the context, May 19th, 6:35 p.m., he discusses paying the 18-year-old for oral sex. So he's interested in having sex with whoever this person is he believes to be 18. So you would agree with me that once the real age or, fake age is revealed one day later or 2 days later, he's undeterred. He talks about the legal ramifications of all of this, but yet after she reveals her age of 14, he texts with her over 75 times. Now I understand, and what concerns this court very much is the law enforcement officer suggesting certain specific sexual acts. But this is a person that continues to maintain contact to the point of telling her what to wear specifically of a sexual nature. And when asked about condoms, he said he could get them. So I think Judge Silberman's question is a legitimate one, because we're dealing with someone who says, listen, I'm alone. I get it. I get he's vulnerable and what happened to him. We appreciate his personal circumstances, and he does voice those in text and with the police. But yet he continues to maintain contact with her to the point where when she says she's excited, and he keeps saying, I'm getting off on your photos and all this other kind of stuff. I mean, that's ambiguous. That could be interpreted both ways. And then when she says she's excited, he says, can I come to your house? So help us out. How do we find that that's an error as a matter of law and not a jury question?
Well, because first of all, as I mentioned, the intent, first of all, it says predisposition prior to these events. But the intent question, the alluring and tiring and soliciting, as I mentioned, the rule of 90 requires that it is DEMARE who says, I'm interested in sexual activity, and not to an adult, to a child. And there's a big distinction when he says on the 19th, I'm interested in oral sex. That may be evidence of something other than a violation of 847.0135, because at that time, that was to someone who would be of legal age to do so. But immediately upon the announcement that this person, when she asked, how old do you think I am? He says 18 or 24. And when she says, the fake Amber says 14, he immediately says, no. Can't talk to you anymore. Can't engage in anything sexual, can't do anything. And it is that point.
But then he goes and tells her he's great in bed.
Well, the state agent is the one.
And then the state, well, the state agent says it doesn't mean we need to F or other things. And then he says, we may have that discussion, nothing too risky. Then he offers her Xanax and pot. And then he says, well, we're not going to be sitting there smoking weed, watching TV for nothing.
I understand.
We've got to look at this in the light most favorable to the state.
Well, then that shifts us to the question of entrapment, which can be decided and is properly decided as a matter of law in a motion to dismiss. If the court is persuaded, it's necessarily true that for entrapment to apply, an offense had to have occurred. So subsequent to the protestations of Mr. DEMARE that he's not going to continue to have conversations with a 14-year-old, it is the law enforcement agent that says, oh, it's so hard to have friends. Please be my friend. Please talk to me. It doesn't mean it has to be about this. It is the law enforcement agent that says there's other things besides effing. It's the law enforcement agent that says, can you get me drugs? It's the law enforcement agent that says you can trust me. It's the law enforcement agent that says, maybe I'll be able to change your mind. And it is the law enforcement officer that says, I accept that you will be coming to my house. There's no, DEMARE says on the record, page 117, there's no effing way I'm coming there to have sex or bring you drugs. And he says, I just want a friend. You can see if you can trust me. And she agrees to that. And that is the ruse that law enforcement use to get him to travel, not for purposes of sex. He specifically excluded that. And that there's no evidence of any motive to do anything else. Yes, there was discussion. Yes, for purposes of entrapment, we can look at those things and say, okay, that may amount to an offense. To even get to the question of entrapment, you'd have to conclude that the offense was committed.
You're conceding that your client offered to come to a 14-year-old's house with controlled substances and pot.
No, I am not. I'm saying he told her on page 117 of the record, there is no way I will do that. And in fact, he did not come with condoms. And he did not come with drugs.
Who offered that first? Your client
She
or
did.
the law enforcement
The
officer?
law enforcement officer
Who
asked,
offered Xanax and pot first to a
the
minor?
law enforcement officer said, can you get me ecstasy? It's at the record, page 94 and 95. It was not DEMARE. It was the child. It was the law enforcement agent.
Ms. Mogensen, there's some overlap in this argument between your issue number one and the subjective entrapment issue. So ultimately, which do you think is the stronger argument? I know you led off with the elements test, but some of this sounds really more directed to the subjective entrapment analysis.
Mm-hmm. Well, I believe that the rule of lenity requires DEMARE to have been the one to solicit. And there's nothing in the record that amounts to a solicitation. And I discussed that at length in my briefing, but I do think that the subjective entrapment is well taken because the law enforcement agent in this particular sting operation was particularly aggressive. I mean, they tried to shame him and tell him, oh, you're going to chicken out, you're scared, you're backing out. They tried anger. Well, I don't want you just coming over here and smoking pot with me and falling asleep. I want more than that. They tried seduction. Oh, I want to get more excited. Tell me more things. She was yelling at him on the phone. Tell me what you want to do to me. Tell me what you want to do to me. And he says, oh my gosh, what do you want me to say? I mean, it's extremely egregiously one-sided as far as the law enforcement behavior to try to get this man to commit a crime. And it's probably the darkest moment in his life. And to his credit, he actually puts up resistance for a very long time. And the case law suggests that those are the circumstances where entrapment be found. Entrapment is not just government inducing of criminality, but the second element of entrapment was the accused awaiting or ready and willing without persuasion to commit an offense. And there was an enormous, a ridiculous amount of persuasion involved to try to get this man to commit an offense. And that does offend the principles of entrapment. So
Did law enforcement ask for a shirtless photo?
Actually, Mr. DEMARE asked for no nudes, please, after
Law enforcement actually said, never will I send nudes. So my question is this: was your client enticed in sending that shirtless photo, or
yes.
was it unsolicited?
I would say yes. Here's the question. I memean, the questions are being directed at me, Justice, suggest that if you commit the crime, you can't be entrapped. The facts that are being focused upon in the questioning are the facts of criminality. But the question then turns to, was that drawn in by law enforcement overcoming his resistance? And the answer is yes. What legitimate government purpose is served when a man says, you're 14, I can't talk to you, no way, it's against the law, I wish it were different, but it's not. To try to make the man feel bad and say, oh, I still want to be friends, it's so hard to get friends, and then for the government agent to then turn back to sex again. That is not a legitimate purpose being served, and certainly it's entrapment that only those who are ready and willing without persuasion to commit the offense be arrested and convicted of the crime.
But we're looking at two strangers that are communicating, and your client is the one that brings up the fact he's going to buy her a microphone. And also coochie shorts or something I've never even heard of, which is something of a sexual nature. So, I mean, I'm trying to figure out how he was solicited, how he didn't have why there isn't a question of some sort of predisposition.
Because predisposition is pre-government interference. That's from Munoz directly, that the evidence of predisposition must exist before the government persuasion. The portions of the record that the court is asking about are post-government persuasion. They're after Amber says there's other things besides effing. That's after Amber says, I may be able to change your mind. That's after Amber says, I'm going to take a shower and get nice and fresh so I can change your mind when you come over.
But that's also after your client said, no way, no how.
Well,
so we've got to weigh that. Your client said no way, no how, but he did not disconnect.
Well, entrapment is the persuasion by the government that overcomes the resistance. That's what it is.
Well, Ms. Mogensen, isn't your point that when he says we can't talk any further, the officer then responds, well, I'll be your friend, and then continues to elicit statements of a sexual nature or encourage him to make statements of a sexual nature, correct?
Correct, and continues all the various efforts at persuasion, including, foot stomping, shaming, promises.
But I want to ask you another question. The judge at the beginning of the hearing finds that your client met the burden to show lack of predisposition. At the end of the hearing, the judge then goes back to it and says, he talks about a case and then says he failed to establish that an agent of the government induced him to commit the offense as charged. He likewise failed to establish a lack of predisposition. So was the judge revisiting the predisposition analysis? I'm not quite sure if I'm convinced that he revisited it or he applied an incorrect standard at that point. And I don't recall you specifically addressing that in the brief.
It necessarily has to be an incorrect standard because the court had ruled, and frankly, the witnesses testified that they had no evidence of predisposition. They had not heard of DEMARE. They had no reason to suspect that he was committing sexual offenses or had a predisposition to do so. And then the court found that the threshold burden was met. Once that happened, the burden shifted to the state. So the court necessarily was applying an incorrect standard at that point and not holding the state to their burden to overcome beyond a reasonable doubt the notion of predisposition. And I think it's important also to note that the entrapment need only be shown by preponderance, which I think we overwhelmingly did.
So is the court able to revisit the predisposition analysis at the end of the case? Is there anything improper about that?
Well, I can't say that I think that it's improper for a trial court to revisit an issue, but I do think that either it was the wrong standard or it was wrongly decided because the facts did not hold any evidence of predisposition. The law enforcement officer testified they didn't have evidence of predisposition. The state did not put on any evidence of predisposition. The evidence of the alleged defense cannot be part of the predisposition. According to Munoz, it has to be something that existed prior to the law enforcement contact.
Very good. And we're at the time for you to reserve your rebuttal, or you can continue forward as you wish.
I'd like to reserve.
Very good. Mr. Koklanis.
May it please the court, Peter Koklanis for the Attorney General's office. Why don't I start by briefly pointing out some of the defendant's post-Miranda statements that I didn't highlight in the brief, but that are probative of guilt. Now, granted, he doesn't ever outright admit, and he does qualify everything with, I wasn't actually going to go have sex with her, but he does make some statements that are probative of consciousness of guilt and his illicit intent. On 134, he says, I'm going to jail. I can't believe this. I should have known. I'm fucked. I'm definitely going to jail. He later says, I basically caved to what she was asking for, but obviously it's the state's position. It's a jury question whether he caved to what she was asking for or whether he independently wanted what he suggested. On 195, I'm admitting my crime right now. On 198, I'm so fucking lonely. It's not even funny. Like I said, I got nobody. And this is the significant part. I'm not trying to use that as an excuse. It's not, because I drove over to a 14-year-old's house. Now, why that's significant is he later does try to suggest it's an excuse in his motion to dismiss. So obviously it's a jury question whether the loneliness is really a valid excuse. He also says, I screwed up. I mean, take me to jail. I don't know what to do. I made a poor judgment call. I wanted attention. And then he also mentioned that he has a 138 IQ. Judge Silberman, I can't hear you.
Can you hear me?
Now I can.
Does that all go to the first issue on appeal, or does that go to the entrapment issue?
I think it goes to both. The first issue it shows, and in the second issue it shows his sexual intent. He's defeated. He thinks he's going to jail. He should have known. So I mean, it's circumstantial evidence of consciousness of guilt, but it also could go to the entrapment issue.
It's clear from his statements to her or to the officer that he knows what's illegal, and he knows about the shows, the TV shows. He knows about these sting operations, and he says, I'm not interested. When she says, I'm 14 years old, he basically says, I'm not interested. I can't talk to you anymore. And then she throws out the offer of friendship. And then she continues to push and encourage him back to the topic of sex. So why, is he held to an admission that I committed a crime when the crime was committed on his argument of entrapment, at least one of his arguments?
I mean, I'm not saying he's held to that admission. It's not clear what crime he's admitting to, but I think it's consciousness of guilt. He's not strictly adhering.
What's illegal? Is it consciousness of guilt that he intended to have sex with this girl, or it's consciousness, I know it's illegal, I'm going to jail because I showed up?
I mean, I think it's circumstantial consciousness that he knows it's illegal, and of his intent, his pre-existing intent. And I think the fact that he knows this is a to catch a predator sting and knows of the consequences goes to his ultimate decision. He had every reason not to go there. He's basically he's like a devil and an angel on his shoulder. The angel saying you could get arrested. He's vocalizing this, and yet he still decides to go forward on his own volition. So he knows.
But isn't that exactly what the Gannett case and some other cases talk about, where the reluctance or unwillingness of a citizen to engage in that conduct is overcome by police persuasion and police encouragement?
Well, we disagree that it was specifically overcome by their encouragement, or that their encouragement rose to a level that constitutes inducement. And it's not a genuine kind of concern. It's always just because he's vocalizing the consequences doesn't mean he genuinely doesn't want to do it. He's really just evaluating, can I get away with this? And you see that from the very.
Your argument seems to do away with any real hope of a defense of entrapment in any case, because you have someone who says, in this case, look, I'm not interested in a 14-year-old. We can't talk anymore. I'm only looking for friendship. I only want to play Mario Kart, all the things that he says. And she continues to push back on that. And so that's what I'm troubled by, is the conduct of law enforcement seems to be very capable of overcoming a citizen's unwillingness to participate in a crime. And that seems to be, at least arguably, what is happening here. Tell me why that's wrong.
Well, first of all, we have to remember it's a jury question by default. It is arguably what is happening. That's what they're arguing. But, any defendant can be disingenuous. And it's important to note that these defendants have become sophisticated. They know about to catch a predator. They know about stings. So in short, there's going to be three types of guys officers might encounter. The guy who's like, yes, he just agrees gung-ho. That's an easy case to prove. Then there's a guy who says no, and he means it. That's the case we want to watch out for, and not let that guy get entrapped. Then there's
then that begs this question, Mr. Koklanis, because if you look at 35103 on May 20th, 2018, that is the key statement by the appellant. I can't talk to you anymore. Please don't take it personal. So convince us, what is the legitimate law enforcement purpose for continuing to pursue communication with him, as opposed to every other person who's trolling this site? What is the legitimate purpose? We've got to make an interpretation of what "I'll be your friend" means from a law enforcement officer who knows this particular unique suspect has lost family members, etc.
Well, there's 2 points. There is a legitimate purpose, and their methods still don't rise to inducement. The legitimate purpose is that they know that there's a third category of guy, which is a guy who says, oh no, I would never have sex with a minor, but he's only pantomiming that. He's saying that disingenuously because he knows that police are out there, that stings are out there, but he really would. And it's a fair point given, how many minors are on the internet and how many men are on the internet and could contact them, for police to craft an investigation that does the bare minimum of testing for genuineness. Is this a real no? Is this a genuine no? Or is this a no? Let me look. Is there any law enforcement officers around? Are your parents around? Where are your parents? Are you a vindictive person? So he's testing whether he can get away with this. And that's a certain type of predator who, despite saying no, doesn't mean no. And the analogy that I thought of, it's not a close analogy, but it's a loose analogy, is imagine the FBI is trying to infiltrate the mafia. They send in a CI, and the mafia, and the CI offers, well, I'm in the cocaine business, I can run cocaine for you. And then the mafia boss, he's smart. He says, no, I'm a legitimate businessman. I don't deal with cocaine. I don't trust you. So does the law enforcement have to sever ties at that point and say, oh, operation's over? They know they're dealing with a sophisticated person who might speak disingenuously and not say what they mean and beat around the bush and pretend to be legitimate when they're not. Now, this defendant.
When a suspect or a target displays some sort of indecision or hesitation, is it okay for law enforcement then to shift the conversation to illegal drugs and say, do you like ecstasy?
Well, on the drug subject, the defendant did bring up weed first when he thought she was 18. The law enforcement officer, based on my recollection, then does say, do you have E? And then the defendant independently says later, no, but I have Xanax and weed. So he did bring up drugs first, arguably as an inducement to the 18-year-old. And I mean, I don't think that question about having E came up immediately after defendant refused. And as to the defendant's refusal, I want to be clear that what law enforcement did metaphorically was just keep the opportunity open a little longer, precisely to test for genuineness. I mean, I could imagine a situation where they do really pressure him and coerce him and try to steer him back. But here, this is just metaphorically like you created a door. It's an open door that the defendant could walk through. He initially said, no, I can't do that. That's illegal. All the police do at that point, they could close the door and burn it down, but all they do is just keep it open and say, well, we could be friends, whatever, maybe, just to see if he's still willing to walk through that door. And that doesn't rise to the level of inducement. That just rises to the level of keeping the opportunity a little bit open a little bit longer. And the reason that's reasonable is precisely because you might have men who encounter a 14-year-old and vocalize some hesitation, either because they think it's a law enforcement operation or because, they just thinking about the consequences. But if they on their own, 2 minutes later, are like, I might go through with this because, why not? If they're the one making that decision on their own, and you can see the defendant almost inducing himself. He says the comment about the 1800s. He says this would have been legal. If you were my girlfriend, this is what I would do for you. So he's really weighing the consequences himself. And ultimately, he walks through the door himself.
Well, doesn't it make a difference here that it took, I think, 4 or 5 days before the age was actually disclosed? So he's having a conversation with the, supposed victim here for 4 or 5 days, which he believes to be an adult conversation. What was the reasoning why law enforcement took 4 or 5 days to finally make the disclosure after they had developed some sort of relationship?
I mean, I agree that that's a point worth examining and it's a significant fact, but it doesn't necessarily rise to either level of entrapment. As to the reason they did it, I can't tell you the exact reason. I mean, I could speculate they probably have a lot of chats going, and I don't know if they plan to wait this long or they may have just kind of waited for the right moment sort of thing. You can see that they don't disclose it till the phone call happens. So maybe they're waiting for it to transition into text from internet. But I think what's most significant about that is, and I'm not saying there's a hard number of days that is okay and a hard number of days that's not okay. What I'm saying is if you look at the volume of this text, there's really not that much in the first 5 days. In fact, on one day.
Well, but what you learn in the first 5 days is the circumstances of Mr. DEMARE, that he's lost family, he's lost a dog, he's lone. So, I mean, you do learn a lot about him and his.
You do. And I'm not sure that renders it unreasonable for police to proceed. I mean, first of all, they don't have to take what some guy on the internet is telling them 100% seriously. He could be saying all this for sympathy, even if he really did, lose his father. Well, people exaggerate on the internet. Maybe it was a year ago. He could be just trying to get this girl to feel sorry for him to get it. So he could be exaggerating. They don't know the full depth of his mental health history and what therapy he's undergoing. He does say my dad died and I'm lonely, but that's pretty much it. And they could take that with a grain of salt. And also, I don't think it requires officers to disengage because real people, to be blunt, need to be able to resist seducing a 14-year-old, even if you're depressed and your dad just died. So I think, that doesn't ameliorate the threat that he might pose to a real 14-year-old should he encounter a real, precocious 14-year-old who's acting older than her age on the internet.
What these transcripts and in these chat conversations, what establishes that the defendant, was attempting to seduce, solicit, lure, entice, or attempt to seduce, and so forth? It seems to me, if the roles were reversed and he were a cop, her statements would be, and a cop representing himself to be underage, it seems to me her statements as the purported defendant would be solicitation of a minor. I'm having a hard time with his statements and his conduct over the course of those calls, especially once it's known she's 14. What does he say that's an effort to seduce her or solicit her?
Okay, I have a fair amount I could say about that, but I just want to point out the fact that law enforcement said a few things where they open-endedly solicited him, like, what do you have in mind? That's not per se improper. In fact, the jury instruction says it's not entrapment just because law enforcement created an opportunity. And I believe it even says solicited an opportunity. So, I mean, just because they explicitly offer an opportunity, which could be considered a solicitation, and also they don't explicitly say that much. It's sure there's a sexual undertone to everything, but they really are just like, well, what do you have in mind? He could have said Mario Kart. Instead he said, well, we're probably going to do other things. And then, he says the comment later about, oral sex. So, and in fact, even after he initially refuses, the officers say, sure, well, we can still be friends, do other things. Well, other things is open-ended enough that they're not really putting very specific words in his mouth. Now,
Okay.
as to his,
so what are the words out of his mouth that
okay.
solicitation?
And let's remember, it's not just solicitation, it's seduce, solicit, lure, entice, or attempt to do those things. So first of all, he mentions, as he's sending one of the photos after he knows she's 18 or after he knows she's 14, it's big. The prosecutor harped on that a lot because it clearly in context means his penis. He mentions and agrees to pick up condoms. That's a seduction in the form of making the whole situation easier and safer.
Asks him about condoms, correct?
She does, and that's partly to clarify that there's a sexual intent.
He responds to her.
True. But I'm arguing that's not per se, entrapment or necessary. It clarifies his intent. He says he's great in bed. That's 15 minutes after her age 14 is disclosed. Remember, even the stuff that he says in the abstract, like I'm great in bed, he's saying this to a minor.
He says, I look young and I know I'm cute, but I'm much older. He said, I'm sorry. I'm going to make sure I've got that right. Incoming, here we go. I look young and I know I'm cute, but I'm much older. Nope, I like older guys. Ones my age are pussies, not men. He says, God damn, you are so beautiful too, LOL. Why can't you be 17, turning 18 in a month? True, I don't play games. I respect women. And then it continues on fairly innocuously. And then she says, doesn't mean we need to fuck. We can do other things. And then he says, let's not talk about it. If we meet up and hang out, play Mario Kart, we may have that discussion, but not right now, nothing too risky. I mean, I'm troubled because every statement that he makes that I think the state argues in its brief as indicative of his attempt to solicit, lure, and so forth, are all in response to her encouragement or in response to specific statements. Do you have condoms? Do you have ecstasy? So tell me where we should draw the line in this case as to where police conduct goes beyond what's appropriate and potentially entraps a citizen who isn't interested in engaging in unlawful conduct.
Well, I think it's important to acknowledge that we have to view all this in the light most favorable to the state, and creating an offer, even a straightforward offer, isn't necessarily inappropriate. So the fact that they're opening the floor to him is that, what are you interested in doing, and so forth, that just gives him an opportunity to show his intent. That still doesn't go towards the level of arm twisting, coercion. She's not saying like, I'm so lonely, I need a man to teach me the ways of womanhood or whatever. I mean, she's not going that far. It's still
Well,
ultimately.
hold on just a second, because at 4/22/06, he basically says he's lost his family, and honestly, I just need a friend. So law enforcement responds by saying, I'm lonely, I'll promise to make you laugh, and sends him an unsolicited photo of that minor girl, and then starts sending him photos to draw him back to the topic of
Well, our
sex.
position
And
is
then
that-
later on, 4:45, he says, if everything was legal, I would snap you up in a heartbeat. Then he refers to the laws in the 1800s and everything else. And then she sends more pictures and he compliments her. This is unsolicited photos. So who's directing who to sex here?
Well, I mean, first of all, I'm just not sure that's outrageous or enticement, because I think we have to take every crime in context. And this is a crime where they're role playing a girl who is sexually curious. And that's part of the crime. You don't have to role play a puritanical minor who has no interest in sex whatsoever. And, you know, take the example of a prostitute on a street corner. You know, a defendant stops and says, hey, what are you doing? And the prostitute might say something sexual. That's not necessarily entrapment if it's part of the job, you know, that they're advertising. A person could still say no. So I think as they're realistically playing a sexually curious minor who's on the internet, they can go a little bit in that direction. And nothing they said is that on the nose that it really, you know, twists the arm. And remember, we're talking about a 14-year-old girl talking with a 38-year-old man, or he believes it's 14. So, you know, at the end of the day, a grown man has to resist the vague sexual, you know, touching up on a conversation by a 14-year-old. I still submit that's not an unreasonable operation, given that this could happen legitimately on the internet. You know, it certainly wouldn't be a defense to real statutory rape. And the fact that it's law enforcement, I'm just arguing they didn't go over the line. And I would point you to the, back on solicitation, the Hartley case, which is a case where the court basically quotes another case called the Groves case, and they quote it extensively. But basically what that stands for is a position that the solicitation doesn't need to be 100% explicit. You can use context. If it's clear they're talking about sex, even if he doesn't spell out, we're going to have sexual intercourse, you can use context. And some of the quotes from that case involve a situation where they were talking about sex early on, and then another day goes by, and then on the third day, the defendant makes vague comments like, I just want to do anything for you and make you feel good, and we can just kind of explore our bodies. And the court said, that's fine. That's clearly, you know, about sex. So in this case,
page 13 of the phone call, Mr. DeMare says, I feel like that's so incriminating, though. Oh my gosh, what do you want me to tell you? And he's asking a question. F and stuff, obviously, like, do you want me to say this about oral sex? Is that what you want to hear? Is that a solicitation or is that an inquiry?
well, I think the fact that he comes up with oral sex, eating pussy on his own, and automatically assumes that it's about sex. And also, I mean, we have to view this in the light most favorable to the state. I think we'd be viewing in the light most favorable to the defense if we treat him as this bumbling, oh, well, what does she want me to say? I mean, he clearly has already, in other quotes, made clear, okay, let's not talk about that over the phone. For my benefit, we got to protect myself, nothing too risky. So he's clearly sophisticated enough that he's dissembling. You know, I think we have to take everything he says that's self-serving and say, I just want a friend, I just want to hang out, like that quote. You have to take that with a grain of salt. He might just be pantomiming, you know, acting like an innocuous person, when in fact he's already given up the game when he says right after, you know, she says we can hang out, he says, well, we may have that discussion down the road when I meet you in person, when I can trust you. And he's already made his sexual intent clear. So I think he does enough independent things that it's clear that the law enforcement is just, they're just opening the door, giving an opportunity. You know, is there a little nudge here, a little nudge there? Maybe, but I don't think that still doesn't take it out of the jury's hands. You know, it has to be particularly objectively such that no reasonable juror could disagree that, you know, he was subjectively entrapped in order to do that. And that's a very high standard.
Mr. Koklanis, I allowed Ms. Mogensen an extra couple of minutes, so you've got about a minute left. You're at 22 minutes now.
Okay, I would just point out that as far as the entrapment and the defendant's refusal, you know, they just kept the opportunity going like a real minor might. You know, they just kept, you know, a conversation going, and ultimately everything the police say is not enough to constitute objective arm twisting, coercion, and so forth. And as far as the 5-day wait, the initial chats overall are pretty short before they get there. And they, for example, on, I believe it's May 19th or 18th, there's only 2 lines. The defense says, I won. The officer says, oh, that's great, winning usually is. And that's it for that day. So we're talking about overall pretty light casual chat. And they don't really seem to emotionally engage. In fact, in the phone call, the police officer says, I'm not looking for anyone to get emotionally attached. I'd also point out that just some of the overall techniques he's doing, like complimenting her. He says that she's adorable, she's gorgeous, she's a goddess. That could be considered part of an overall, you know, trend of, you know, seduction, luring, enticing, trying to make her feel comfortable. He explicitly states that he wants her to feel comfortable. He's willing to do what it takes to make her feel comfortable. He offers to pick, you know, to go there in his car. He talks about his little dog, which he, you know, believes will make her feel comfortable. And that does create a factual.
That brings us to the conclusion of your, thank you.
We would ask you to affirm. Thank you.
Ms. Mogensen?
The case is appropriate for a determination on the motion to dismiss because the question of whether the essential elements are present and the question of entrapment are matters of law, and there are no disputes of fact. So there's no jury question here when there's undisputed facts. There's no facts that are relevant besides those that were presented in writing. And these parties, every single portion of this investigation was recorded and transcribed. So there's no dispute of fact to present to a jury. And frankly,
is the fact, am I recalling correctly that when he showed up at the house, he did not have condoms and he did not have drugs? Or
correct.
Did he have a little bit of marijuana? I'm trying to recall now.
He had no condoms, he had no drugs. There was apparently like a butt of a roach, like very minor, in the ashtray of the car, but he did not bring it to the house or bring it in the house.
So,
and when he was interrogated, he indicated that he lied about having marijuana and didn't know the roach was in the car until the cops told him. That's what he said.
Do the facts surrounding his appearance at the house get weighed into this analysis?
I think they do, and I think they weigh favorably for him. He said on page 117 of the record, I have no intention of coming to the house for any sexual activity or any drugs. And he did not appear with Xanax, he did not appear with marijuana, he did not appear with condoms. I think that suggests that what their agreement was to meet to establish any sort of comfort with each other was what the only agreement that occurred between these parties. But I think that is responding to the state's argument. There are no 3 categories of potential criminals, but if there were, Florida statute 777.201 only permits the government to arrest those in the definite yes category. And we know that from Farley versus State and the jurisprudence on entrapment. That's what entrapment is about. That any government conduct creating a substantial risk that someone other than a law-abiding citizen would commit an offense, including persuasion, fraudulent representation, promises, pleas based on sympathy, need, or friendship, amount to entrapment. That's from Farley versus State. So as far as law enforcement appropriately delving into the second category where no doesn't mean no, that's what entrapment is designed to protect, and that is what is prohibited by the legislature in 777.201. In any light most favorable to the state, or most in any light whatsoever, this person was not in the category of those that are waiting or ready and willing without persuasion to commit an offense. There's no question about that. The guy had no filters. Everything he thought was stated, and he was not precipitously waiting to commit this offense. He said no, and the government agent applied various means of persuasion in an effort to overcome it. And when the state concedes that there was this double angel type of internal dialogue that he was word vomiting into his text, suggests he's precisely who the entrapment defense is intended to protect: someone who is suffering from some type of mental illness or defect, someone who's suffering from circumstances in their life where they're vulnerable from government persuasion. This crime would not have occurred without government action, and that is what is entrapment. In Farley versus State, there's a long discussion about crime that's occurring in need of detection and crime that's created by government action. And this certainly falls into the latter category. And that actually amounts to objective entrapment. I do think the subjective entrapment argument is stronger, but I think there's definitely objective entrapment here too. Government agencies should not be engaged in talking people into driving to become a sex offender when they're clearly not predisposed to do so, when they object to the notion, when they say no. No does mean no. And that's the point at which this experienced detective should have turned his attention to one of the multiple other chats that were engaging his attention in the first 5 days of this arrangement. So I would ask the court to reverse Mr. DEMARE's conviction with instructions to enter grant of the motion to dismiss. I don't think that there's the only way that the motion to dismiss is not appropriate is if there is a material dispute of fact. And as I mentioned in my reply brief, the state abandoned that argument at hearing. That was not preserved for appeal. It's not even a proper question before the court because there was no objection on the part of the state at the trial court level to this being a jury question or not appropriately decided on a motion to dismiss.
Very good. Thank you both, counsel.
Thank you.
That case, the next case is Borges versus Naples Estates Limited Partnership. And for those who are waiting after this third case, we